Hello, I'm Mike Cortez if you prefer, and on behalf of Dr. Sean and Deb, I'd like to welcome you to Gesture Politics' 8th video in our Constitution series, and this one is the 14th Amendment and Birthright Citizenship. There's been a whole lot of arguing and name-calling ever since President Trump signed his executive order ending birthright citizenship for children born to parents who are in the U.S. illegally. Those on the left categorically state that the 14th Amendment provides birthright citizenship to everyone born in the United States, regardless of whether or not their parents are here legally. Those on the right say that the 14th Amendment provides for no such thing, and in order for a child to have birthright citizenship, his parents or her parents must be in the U.S. legally. However, what seems to be missing is people actually coming up with factual support for their arguments. So I thought we'd do a little unpacking of the 14th Amendment. Now, you may call me crazy, but I think a good place to start would be with the relevant section of the 14th Amendment, which is Section 1, and states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. The point of dispute is the language, quote, subject to the jurisdiction thereof, close quote. Those who believe everyone is entitled birthright citizenship claims that this means that the parents are merely subject to the laws of the United States. But that interpretation would render the whole section meaningless and is contrary to the interpretation of the 14th Amendment since 1868. As an initial matter, if the 14th Amendment created universal birthright citizenship, it would have removed all restrictions as to Native Americans being citizens of the U.S. by right of birth since it was ratified in 1868. But it didn't. In 1884, the Supreme Court, in the case Elk v. Wilkins, ruled that a Native American, Mr. Elk, was not a citizen of the United States even though he was born in the United States, because at the time of his birth his parents owed allegiance to another sovereign, i.e. their tribe, and therefore were not subject to the jurisdiction of the United States, even though they were subject to the laws of the United States. The key to this holding is that the person's parents must owe allegiance to the United States before the child receives birthright citizenship. In fact, Native Americans did not become citizens of the United States until the passage of the Indian Citizenship Act of 1924, which would have been unnecessary if the 14th Amendment did in fact provide for universal birthright citizenship. The question of what is required to show that a non-citizen's allegiance is to the United States was answered in 1898 when the Supreme Court decided U.S. v. Kim Wong-Ark. Mr. Kim's parents were Chinese citizens who were legal residents of the United States when he was born. In this case, the Supreme Court ruled that non-citizens who are legally in the United States, quote, owe allegiance to the United States so long as they are permitted by the United States to reside here. In other words, in order for a person who is born to non-U.S. citizens within the United States to receive birthright citizenship is for their parents to have been residing in the U.S. legally. The only way to square the 14th Amendment with denying Native American citizenship until the Indian Citizenship Act of 1924 and the holdings of Elk and Kim Wong-Ark is to accept that the language subject to the jurisdiction of means 1. The person's parents owes allegiance to the United States, and 2. Allegiance of non-U.S. citizens is established by them being permitted to reside in the United States. Therefore, those residing in the United States illegally are not subject to the jurisdiction thereof, and therefore their children do not receive birthright citizenship. Though there is no constitutional basis to extend universal birthright citizenship to the children of illegal migrants, there is a strong non-constitutional argument for it, and that is history. In the 156 years since the 14th Amendment was ratified, the United States has never raised the issue that birthright citizenship does not extend to the children of illegal migrants. To now hold that the 14th Amendment is limited to children of those residing in the United States illegally would cause significant upheaval if it was applied retroactively. Of course, this can be avoided by simply holding that those who have already received citizenship, regardless of the status of their parents, remain American citizens. In any event, this issue will be resolved by the Supreme Court in the near future. The question is will the Supreme Court follow the 14th Amendment and ignore history, or will they follow history and ignore the 14th Amendment? I wish I could answer that question, but I can't. Thanks for watching and have a good day.